All right, Ms. Link. The State of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
The jury, you've heard the judge read the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no.
What's your take on this?
Yeah, I mean, whenever I don't see a reaction to, I think a defendant expects that. And I think with a quick verdict like that, I mean, I think these jurors had their mind made up. I think in order to prove self-defense, you really have to show that your life was in imminent danger and the actions you took were an immediate need to protect your life. And I just don't think they saw that here. There was too many prior incidences, too much evidence that he was concerned for his well-being before he was killed. Too much history of violence, too much of a history of violence that she's instigated. And I think the jury saw that and they made their decision quick. There wasn't enough evidence, I thought, for self-defense here. But that's whenever you have a quick verdict like that, it sounds like they have made their mind up a while ago.
And it's interesting because I felt like it was only about 10 minutes before the verdict, but I don't know, Kelly, it may have been more than that. The jury wanted to see some pictures, and they wanted to specifically see a picture of a back door, perhaps autopsy pictures that were in a demonstrative aid used by the prosecution, but had not been admitted. So the judge with the attorneys got all those admitted, sent them back, and then they came out with this decision. So I wonder, does that mean perhaps there was one that was on the fence and they said, let's look at pictures. They looked at those pictures, and then, Gabriel, shortly after that, we get the verdict.
Yeah. Well, definitely. I think what I learned with my jury trials is that jurors like to see, there's people that are different visual learners. People like seeing pictures, videos, and I think the same thing. I think there was one person that wanted to ask that question, hey, I'd like to see the photos of this, and they gave it to them. And so jurors sometimes they want that. A lot of jurors, not a lot of times, they want the actual see photos. They want to see video evidence. Maybe a couple people weren't sure, and then that was what turned them over to flip them real quick. So that sounds like that could have been the case also. But it's not uncommon at all for jurors to ask the judge or foreman to go ahead and we need a little bit more evidence. Can you get us those pictures? Let's look at this again. And sometimes those are the things that just flip those couple of jurors that might be on the fence about the case.
You know, one of the things that was something that I thought prosecutors would have a hard time with in this case is that the victim, and I'll ask you about that in a second, but they went back on the record there in court in Miami. Let's go back and hear what they're having to say.
It would otherwise be held as PSI. I don't know if the defense is waiving that or not, but I would, if we already have a sentencing other than the waiving of PSI, it would need to be proposed.
Do you want me to order a pre-sentence investigation?
Yes, please.
Okay. All right, so we'll order a pre-sentence investigation. They usually take about 8 weeks, so we'll just reset this for about 8 weeks time. It's going to print tomorrow anyway, Mr. Tomas, because we're after a cutoff date for the clerk of court. 8 weeks from now puts us roughly around Thanksgiving. So I'll just ask for the pre-sentence investigation to come back the Friday before Thanksgiving, the 21st. Is that all right?
That's not I can make myself available.
That's just for the return of the PSI. It's not for actual sentencing itself.
Yeah, that's fine.
Okay, so 21st is the next court date for the return of the pre-sentence investigation. If it's back then, we can pick a day for sentencing after we get the pre-sentence investigation. Is there anything that I need to address from the parties before we adjourn for the day?
I don't believe so.
All right. Thank you all. We're adjourned. because there's none here. I can sign it tomorrow.
Gabriel, so one of the things that I wanted to talk with you about is the victim in this case, Pedro Jimenez. They talked about him being high on cocaine, having a large amount of cocaine in his system, also having alcohol in his system, as well as, I believe, marijuana. So from a prosecutorial standpoint, having a victim like that, that's not exactly easy. So it made me wonder, okay, maybe prosecutors aren't going to have that easy of a time with this case. What do you think about that? But clearly, they did come back in quite a short time with the guilty verdict.
No, I agree with you. I think that's anytime you got a victim that's under the influence of cocaine and alcohol, marijuana, that's not good. Because obviously their behavior, that shows right there that their behavior, they're not going to make good decisions, or there is an impairment in how they normally behave. So I think that's a legitimate concern. However, doesn't necessarily mean this guy was, attacking her, or that he was a threat to her life. But the defense attorney, he did his job pointing that out, and any good defense lawyer is going to really amplify that too. So yeah, the prosecutor, that could have went bad for him. That's definitely not a good fact in their favor. But ultimately, the jury decided, that there was just more evidence of motive and intent to kill this person.
And you can see her getting upset. I noticed it looked like she was starting to get upset when the judge was talking about the pre-sentencing report being due on November 21st, and then a court date will be scheduled for the sentencing. And she is upset there. It looks like she is beginning to tear up, perhaps cry, the emotion, the reality setting in. Just tell us quickly, Gabriel, what is it like when you're sitting next to a defendant and waiting, or any client really, waiting for that decision to come in and the emotion of it?
It's tough. It's tough for the lawyers. It's tough for the client. Whether you're on the good end of the result or a result that doesn't go your way, it's a lot of anxiety. There's a lot of, you get those pits in your stomach, like, man, I hope they get it right. And you just don't really know. That case, the more I've done jury trials, you realize that it really is a jury's case. You can be a good lawyer and you can put your story out there and put your evidence on, but ultimately it's about how that jury feels about your client, feels about the evidence. So it's really out of your hands, and you really just try to sit there and just hope it goes your way. And it's not a good feeling, if you have a client that's got I'm a civil jury trial lawyer. We do a lot of wrongful death cases, and gotten some good results, got in cases where we didn't go our way. So either way, that feeling of fear is there. Then you realize that it's really just out of your hands. And I know criminal defense lawyers have a really tough job. They're the client's lives on the line, and they do what they can, and with the facts they have. So it's definitely not being a trial lawyer is not for the faint of heart. I know that.
No, it's not. I think we can all say from our own experiences that it's a lot. Now, Michael Ayala and I have been texting about this case, even though he's not here. He's here in spirit, because he made a really good point, Kelly. I just have to mention, after the verdict, they didn't put her in handcuffs. Typically, you see the defendant almost immediately getting remanded into custody. They come, they put on the handcuffs. That didn't happen the whole time we were watching.
Yeah, and I mean, we saw her get emotional, though, as you mentioned. So, who I really feel bad for is her little boy. He took the stand via Zoom. It was via Zoom. And you heard about him testifying about how he wants his mother to come home. And so just always tough situations all around.
Yeah, it is. This one is.